My name is Risa Goluboff. I am a professor of law here at the law school. I've been teaching here for 24 years. Now you gasp and say you can't be that old. I am originally from New York City, and all of my education was in the North. So I say this as if you want to come talk to me after. My undergraduate is from Harvard. My PhD in history is from Princeton, and my law degree is from Yale. But my heart is from here, and I don't know if you heard me mention 24 years I have been here. I have visited at NYU, Columbia, and Chicago, so I really know a fair number of institutions and would be happy to talk with you about them. Before joining the faculty here, I clerked for Judge Guido Calabresi on the Second Circuit Court of Appeals, and then I clerked for Justice Stephen Breyer at the U.S. Supreme Court. Here at UVA, I teach first-year constitutional law. I'll talk about that more in a second. I teach legal history classes, constitutional history classes, advanced constitutional law classes, civil rights classes. I was dean from 2016 to 2024. You might have seen a very small portrait out of the way of me somewhere, very small. But I stepped down about a year and a half ago. Dean Kendrick, who I'm sure you've all heard from, is my phenomenal successor. I have written 2 books of legal history. The first one was about civil rights before Brown versus Board of Education, and the second one is about social movements and policing and vagrancy laws in the 1960s and 1970s. So that's about me, and I'm happy to answer any questions that you might have about any of that or anything else after we have our class. All right, so let me tell you some background to Marbury versus Madison. So this is the first case that I teach in my 1L constitutional law class. So you know about what my students know. That's not quite fair. My students have already had a whole semester in law school, but not of constitutional law. And we've just had one class on kind of the background of the Constitution and some introductory issues. So you're really basically where they are when I teach them Marbury versus Madison. And I chose this case for a few reasons. One, it's a very important case. 2, you can be where they are as you think about the course. And 3, it will show you that the professors add value because I see many of you have it in front of you. I'm hoping that you've read it or tried to read it. I know that it's a little opaque and a little dry, and so I'm going to show you really what's going on in the case. So hopefully it will. You'll see how important it is. It establishes judicial review. So we take for granted that the Supreme Court and the lower federal courts review constitutional, and the state courts actually review federal constitutional questions, but that was not something that was inevitable or taken for granted. This is the case that establishes it. And Chief Justice Marshall was not the first Chief Justice of the United States. There were several before him, but they kept quitting. They couldn't get people to take the role. It was not a great job until Chief Justice Marshall came and established judicial review. So if you ever go to the Supreme Court, on the first floor of the Supreme Court buildings, I see some of you nodding, there's a kind of museum, it's a museum. And in the museum, there's an enormous marble statue of John Marshall. And his words, some from this case, are inscribed in the marble walls of this museum because he is so important. And from other cases too. But this case made John Marshall, and John Marshall made the Supreme Court what we know it is today. So that's why I think it's really important to read. So the last thing I'm going to say is I am going to try my very best to finish the whole case, because you really need to get to the end, by the end of our hour. But when I teach in constitutional law, I always allow things to go to the next day. I don't kind of put a stop to things. So I'm going to do my very best to get us to the end. But that's a challenge for me. Okay, so how many of you seen Hamilton? Or no? Okay, all right. I was just asking my daughter, who's 23, is everyone going to know Hamilton? She was like, if they don't, they should. So I figured you did. So Hamilton, the election of 1800, right? Okay, that's what is the backdrop for Marbury versus Madison. As you know from Hamilton, the election of 1800 was a nasty, hard-fought political contest. Thomas Jefferson We are here in Thomas Jefferson's University. Thomas Jefferson was the Republican, the anti-federalist. He was elected. He won the election. He was into smaller, decentralized government. And John Adams was the incumbent who was defeated. And he was the federalist, more into federal power, national power, a strong central government. During the 1790s, as you know from Hamilton, they feuded. There was really very vitriolic politics during the 1790s. And when the Republicans win in 1800, it seems like the end of the world to the Federalists. They are very upset. So at the time, the new president took office in March, not in January, which led to the possibility of more mischief between the time of the election and the new president coming in, where the old administration are lame ducks. And where Adams and his colleagues do some mischief. So one of the things they do is they pack the court. They pass a law to create more judiciary openings, and they appoint new judges. Another thing that they do is they create 42 justice of the peace positions. And John Marbury is the plaintiff here. He was one of the folks who was appointed to be a justice of the peace under this new law. And John Marshall, our same Supreme Court chief, okay, so maybe you don't know this part. John Marshall was the Secretary of State under Adams. He was the Secretary of State under Adams. It was his job to deliver the Justice of the Peace commissions before Adams left office and Jefferson took office. Somehow, he did not deliver Marbury's commission. The Republicans coming in are furious with all of these shenanigans, with the packing of the courts, the creation of the Justice of the Peace, and the expansion of the judiciary. So they repeal the expansion of the circuit judgeships. Unclear whether that's constitutional because there is life tenure for judges, okay. And Congress eliminated the 1802 term of the Supreme Court because they didn't want that law challenged. They wanted to avoid the court hearing that case. And of course, Jefferson refuses to deliver the Justice of the Peace commissions. He told his Secretary of State, Madison, not to deliver these commissions, including to poor Mr. Marbury here. So Madison is the defendant, right? Marbury versus Madison. Madison is the defendant here. Marbury is the person who didn't get his Justice of the Peace Commission, and he is suing. So among the first cases of the new term is Marbury's claim that his commission should be delivered. He should get to be a Justice of the Peace. In the meantime, John Marshall is appointed Chief Justice of the United States. And for 3 months, he is both Secretary of State and Chief Justice of the United States. That's crazy, right? Both Chief Justice and Secretary of State. Oh, for a month. Sorry, not 3. For 1 month. Okay, so he presides over a trial at the Supreme Court whose question was, what happened to the commissions? Why didn't they get delivered? Who do you think knows why the commissions didn't get delivered? Okay, but he doesn't testify. Okay, so we are talking high political drama, and we will see by the end that there's not only drama, but major irony. Okay, so that is the background. Okay, we did about me, we did the background. Now we're going to talk about the case. All right, I was just discussing with early arrivals whether I should cold call. I do cold call in my constitutional law class, but I'm not going to cold call. Okay. Go ahead, breathe out. Okay. But cold calling is good, and when you come, you should embrace it. And in addition, you should embrace volunteering. So I'm going to take a volunteer now, and it's a good thing to raise your hand and volunteer, and you might as well start now. Okay, so I need a volunteer. I'm going to wait till more people raise their hands. Oh. Still only a hearty few. All right, way back in the back. Okay, yes. All right, what's your name? Louisa. Okay, I'm going to come back to some of those other folks. Okay, so what I would like you to do you have the case in front of you? Okay, so after that paragraph of background, I would like you to start reading the sentence where it says opinion of the court, but don't be offended. I'm going to interrupt you. Okay, go ahead.
Okay, opinion of the court.
The last term, what does that mean? I know, it was so fast. When was the last term? What do they mean by the last term? Remember what I told you? They canceled the term. This case is what year? Look at the very top.
1803.
Okay, so they canceled one term. So when did the last term?
1801.
Yes, I know. We promised you no math. This is law school. We promised you. I know. That's why you come. Okay, but you got it right. Okay, so the last term was 1801 because there was no 1802 term. Okay, in the last term, keep reading.
On the affidavits then read and filed with the clerk, a rule was granted in this case.
A rule was granted in this case. Do you have any idea what that means? You are not supposed to know the answer to this question. What was a rule was granted in this case? What does that mean, a rule? Sorry? An order. An order was granted. These are not words we use today. We don't use the words this way. That's why I'm telling you, look at the value I've already added. Okay. A rule was granted in this case, which meant the court issued an order. Keep reading.
Requiring the Secretary of State to show cause.
Show cause. What does that mean? Requiring the Secretary of State to show cause. What do you think that means? To prove. To defend himself. To prove. To defend himself. Okay. Keep going.
Why a mandamus should not issue.
What do you think a mandamus is?
It's an order from, I think, a court or judge ordering someone in the government to do something.
Perfect. Exactly. That was perfect. It is a writ ordering a government official to perform a duty that the government official must perform. Okay, finish the sentence. I'm not going to interrupt you.
Directing him to deliver to William Marbury his commission as a justice of the peace.
William Marbury. I called him John. Everyone else was John, but he's William, so I apologize. Okay. And then read the next part, which there's no way. Go ahead, read the next part.
No cause has been shown.
No cause has been shown. Do you know what happened? Madison did not show up to defend himself. He didn't even come to the trial. Do you remember what I was telling you? The court was not a powerful instrument of government. It was not a powerful institution. The court said, you need to come defend yourself. And Madison said, I don't think so. I am not coming. Okay, keep going.
And the present motion is for a mandamus.
Keep going. One more little bit.
The peculiar delicacy.
The peculiar delicacy of this case. The peculiar, do you hear the peculiar delicacy? Marshall didn't deliver the commissions. Marshall's in charge of the trial. Madison didn't come. This is very delicate. Okay, peculiar delicacy. Okay, at the end of the day, there's a question for everyone. We're going to do some call and response. At the end of the day, is William Marbury going to get his commission? Yes or no? No. Good, excellent, fabulous. Okay, but there are going to be several questions, 3 questions, and the third question has 2 parts. Okay, there are going to be 3 questions to get there, and he has nicely laid them out for us. So the first question is, does Marbury have a right to the commission? Yes or no? Yes. Awesome. Second, does Marbury have a remedy for this violation of law? Yes or no? Yes. Okay, awesome. Is that remedy a mandamus? Yes or no? Yes. Okay, we're getting slightly less confident. Okay, let's do it again. Is that remedy a mandamus? Yes. Okay, good. Can this court order that mandamus? No. Awesome. Okay, so we're going to go back to 1. I'm going to stick with you for 1 more minute, and then I'm going to call on somebody else. Okay, so why does Marbury have a right to the commission, according to Justice Marshall?
I believe that it was because the president has the authority to appoint people, and when he decides that he's going to appoint people, then they do have a right to that appointment.
And at what moment, this is going to be a technical word, at what moment does their right vest? I'm going to call on someone new. People raise your hands. Go ahead. At what moment does their right vest?
When the president signs the order.
When the president signs the order. Did the president sign the order?
Yes.
What do you think Jefferson thinks is the moment when the right vests?
When the commission is delivered.
When the commission is delivered, right? So Jefferson thinks you didn't deliver the commission. Marbury is not a justice of the peace. Marshall clearly thought the right vested at the signature. That's probably why he didn't think it was necessary to deliver the 42 commissions. right? Because it had already vested when it's signed. And what is this based on? The idea that the moment that the right vested is when it was signed. What is it based on?
The idea that appointment and commission are two different things, and the Constitution says that the president has the authority to appoint with the advice and consent of the Senate.
But that's correct, but what is where does the authority that says once it's signed and sealed, he gets to have it for 5 years? Where does that come from?
The congressional statute creating the justices of the peace.
Exactly, right? So the congressional statute says the president has to sign and seal it, and once it's signed and sealed, 5 years. He gets to be the justice of the peace for 5 years. Signed and sealed. Okay, so the answer to question 1, does Marbury have a right? Yes or no? Yes. Awesome. Okay, so now we're going to be up to question number 2. Does Marbury have a judicial remedy? Does Marbury have a judicial remedy? So we're on page 2 now. We're on page 2 now. And he says something quite famous that I'm sure you have heard before, right? We are a government of laws, not a government of men. Why does he say that? What does that mean?
We don't have a king, for example, who can just make laws. Even the president is subject to the law.
And so if you have a right, you therefore must have a remedy, right? Every right should have a remedy, says Chief Justice Marshall, because we are a government of laws, not of men. Now, there are some claims that do not have remedies. There are some claims. What kinds of claims don't have remedies? What kind of claims? Somebody knew. What kind of claims don't have remedies? Legal claims have remedies. What kind of claims don't have remedies? Go ahead. Political ones. Political claims. Now, what if Marbury and Marshall had been down at the tavern having a drink, and Marbury said, hey, make me a justice of the peace, and Marshall said, sure. And then John Adams was like, I don't like that guy. I'm not going to make that guy a justice of the peace. Would Marbury have a legal right?
No, because he hasn't signed the legal rights.
Because he hasn't signed the commission. The president has total discretion over who he's going to nominate. He gets to choose who to nominate. There are many acts that political actors engage in that are political acts, not legal acts. And if they're political acts, they don't lead to legal rights. So does every right have a remedy? I don't know, right? What would the remedy be? What might the remedy be if a politician does something you don't like and there's no legal remedy for it? Somebody knew. Go ahead, in the back. An election, an impeachment, a pardon, right? We can imagine lots of kinds of political remedies that are not legal remedies. And are those reviewable by the court or not? Yes or no? No. Political acts by the executive and the executive agents are not reviewable by the court. What kind of acts are? Legal acts are reviewable by the court, not political acts. And this is the beginning of what is called the political question doctrine. The political question doctrine, which is the idea that the court is not going to get involved in political questions. When the elected branches, Congress, the president, when they are making political determinations, deciding who to appoint, who to confirm, whether to impeach, whether to pardon, decisions that are in the discretion of the political actors, the court will not get involved. Why might the court not want to get involved? Why would the court say we don't get involved in political decisions? Yeah.
Isn't the court supposed to be like apolitical in a sense?
Yes, it's supposed to be apolitical, so it might be protecting itself, protecting its legitimacy. Yeah, why else?
Because of the counter-majoritarian difficulty and sort of the fact that they sort of become sort of tyrannical because they're an unelected group of people.
So if that's the case, why is there a difference between political and legal? Isn't that a problem for legal decisions too?
Well, it is, and a lot of political scientists will argue that, but it is less of a case because legal questions are much more limited in comparison.
Okay, so we're going to talk about that at the end. Other reasons? Somebody new? Yeah, go ahead. You and then you. Go ahead.
Because the branches of government are intentionally separated.
So there are unique decisions that are meant to be made by unique governments. Were you going to say the same thing? The court doesn't have the authority. They don't have the expertise. That's why we have separation of powers, right? Okay, so there are lots of possible reasons why the court might not weigh in on what are called political questions. So remind me, why is there a remedy here? I was talking, yeah, go ahead.
Because it's a legal question?
Because it's a legal question. This is a legal question. Who decides whether the question is a legal question or a political question? Yeah. The court decides whether they get to. Yes? Yes. So, remember the big chair? Remember, this is Marshall making the court a big thing. So second question, this is the question, second question. This is the first aggrandizement of the court's power. Is Chief Justice Marshall saying, there are times when the court can review the actions of the executive branch. We get to say whether the executive branch has done something wrong. There is no, the other way to put that is to say, there is no pure executive privilege. The executive branch is going to be constrained by the court. And who, again, is going to decide when the executive branch can be constrained and when it can't? Who decides? The court. Okay. And the court decides the action here is reviewable or not reviewable? All right, let me try that. The court thinks the action here is reviewable or not reviewable? Reviewable. Because this is a political act or a legal act? And it's a legal act because of what? That wasn't a good one. It wasn't a good call and response. It wasn't good. Okay. Because of the statute, right? The statute says, now if the statute had said, once it's signed and sealed, he is a justice of the peace and he serves at the pleasure of the president, would he have a legal right? No, he wouldn't, because it would remain within the discretion of the president to remove him at any time. But that's not what it says. It says 5-year term. Signed, sealed, 5-year term. The president cannot just remove you. This is a legal right that William Marbury has. Okay, so finally we get to the third question. Is Marbury entitled to the remedy that he seeks? And that remedy is the writ of mandamus. And the answer to that question again, yes or no? Yes. Okay. That wasn't clear. Okay. Is mandamus the right writ, yes or no? Yes. Is he going to be entitled to the writ? No. No. Okay, great. Just so we're clarifying. Okay, so he asked for the right writ. Why? Why is it the right writ? You already told us. Someone already told us. Did you tell us? Who told us? You told us. Why is it the right writ? Yeah.
Because the writ of mandamus is ordering government officials to perform certain actions and forcing Adams, theoretically forcing Adams to give him his commission would be would fall into that.
Okay, forcing Madison, right? Forcing Madison and Jefferson. Yep. Exactly. So a writ of mandamus is an order to a government official to perform a duty that that official is legally required to perform. Is that what we have here? We have a duty that is legally required, and so a writ of mandamus would be the right writ. And if we look at, on page 3, turn to page 3. If you look at section 13 of the Judicial Act of 1789, it says in the last sentence, the Supreme Court shall also issue writs of mandamus in cases warranted by the principles and usages of law to any courts appointed or persons holding office under the authority of the United States. So it is the Judiciary Act of 1789 that gives the court authority to issue a writ of mandamus. Okay. But there's no mandamus. Marbury is not going to get his commission because the second half of this question is no. The second half of this question is no. Why? Because this part of the Judiciary Act of 1789 is unconstitutional. unconstitutional. Now, let me tell you, I'm going to, Professor O'Brook was teaching Civ Pro next door, and if that gets recorded, you should watch that too, because she's an amazing professor. If you can take a class with her when you come, you should. So she's doing civil procedure over there, but I'm going to just tell you one little civil procedure thing. In civil procedure, you always want to ask the jurisdictional question first. Does the court have jurisdiction? And everybody knows, every first-year law student learns very quickly, if there's no jurisdiction, the court shouldn't answer any other questions. There's no jurisdiction here because the statute that would have given the court jurisdiction is unconstitutional. Why is this the third question in the case and not the first question in the case? Why do you think? Why do you think this is the third question in the case? Go ahead.
I'm assuming because John Marshall wanted to establish the court's power, and this was an opportunity for him to do it.
Yeah, he wanted to say, we can review executive actions, which is what he does in question 2. We can review executive actions, so he doesn't answer the jurisdictional first. That is not good first-year law student behavior, just so you know. And he's going to have some other not good first-year law student behavior that you're going to see in a minute. But okay, but he still gets the chair, and you'll see why. Okay, so what does Chief Justice Marshall say makes this statute unconstitutional? Somebody new. Somebody new. Come on, somebody new. Raise your hand. I can wait. Thank you. Go ahead.
A mandamus has to be issued through appellate jurisdiction, and this has been brought up under original jurisdiction, so they can hear it.
Exactly. So, good, because that's a hard question, and I'm glad you were brave. Okay, so the statute, the Judiciary Act of 1789, expands the original jurisdiction of the Supreme Court beyond, according to John Marshall, what Article 3 says it is allowed to include. And because it expands it, you can't do that. There's a conflict between the statute and the Constitution. It is unconstitutional. So what's the difference between original and appellate jurisdiction?
Appellate jurisdiction is it's coming up from the lower court, so it was appealed from there. And then original are the cases that the courts could just hear right off the bat.
And which one is this?
This is coming up under original jurisdiction.
And why is that? What do we know happened at the court?
Because it came directly from the president requesting court.
It is right at the court. They had a trial at the court. A lower court didn't have a trial that people then appealed from. The trial was at the court. This case was brought at the Supreme Court. Okay, so Marshall says, I want us all to look at Article 3. Marshall says, let me just tell you his argument, and then I want you to look at Article 3. Article 3 does not give original jurisdiction for mandamus. Article 3 does not give original jurisdiction for mandamus. So when Congress gives original jurisdiction for mandamus in that sentence that I read to you earlier, it is unconstitutional. It goes beyond what Article 3 can do. Appellate jurisdiction corrects a lower court. Mandamus corrects an officer, Secretary of State, right? That's the other way to think about original versus appellate. Okay. Was anybody confused if you read the Judiciary Act of 1789? Was anybody confused by why Madison wasn't covered by the language that says, if you look there, sorry, I know, I made you turn to Article 3. You got to go back. Okay, so go back. Look there, the fourth line down, and shall have exclusively all such jurisdiction of suits or proceedings, again, and such jurisdiction being original jurisdiction, that's what's in the prior sentence, against ambassadors or other public ministers. Why is Madison not an other public minister? Who is meant by other public ministers? Anybody? Yeah. Nope, not elected people. Yeah, somebody new? Who might be meant? Think about it in the context of the sentence. Ambassadors or other public ministers. Who's meant? Who's like ambassadors? Yeah. Yes, other foreign ministers. Other foreign ministers. But when I read those words, I think, couldn't that be a minister here in the United States? Okay, so when you start learning about methods of constitutional interpretation and you start thinking about textualism as a potential method, when you read this sentence, it could include domestic ministers. But no one even mentions that because it's so obvious to them that that sentence is about foreign ministers, right? So Marshall doesn't even concern himself with that because he knows that's about foreign ministers. So you should think about what's obvious, what's not, how do we think about the text, how do we think about language and how it changes over time. Okay, so there are two problems with Marshall's reading. The first problem with Marshall's reading is, okay, this is just reading out loud. So I expect new people. I'm going to have somebody read out loud one thing and somebody read out loud another thing. So raise your hand, new people. Come on. Great. Okay. I want you to read out loud on the top of page 4. That first full paragraph where Marshall quotes Article 3.
With the Constitution vests.
Yes.
The Constitution vests the whole judicial power of the United States in one Supreme Court and such inferior courts as Congress shall, from time to time, ordain and establish.
Keep going.
In the distribution of this power.
This is the key, right? Because we're talking about the distribution between original and appellate jurisdiction. That's what this case is about. Keep going.
It has declared that the Supreme Court shall have original jurisdiction in all cases affecting ambassadors, other public ministers and consuls, and those in which a state shall be a party. In all other cases, the Supreme Court shall have appellate jurisdiction.
Okay. Can somebody else read me Article 3 that I gave you at the back of your packets? Again, this is just reading aloud. Great. Go ahead.
In all cases affecting ambassadors, other public ministers and consuls, and those in which a state shall be a party, the Supreme Court shall have original jurisdiction. In all the other cases before mentioned, the Supreme Court shall have appellate jurisdiction, both as to law and fact, with such exceptions and under such regulations as the Congress shall make.
Okay, so it's not fair because I said it was just reading. But is there any difference between Article 3, the way Marshall quoted it, and Article 3, the way it actually is in the Constitution?
There's an exception.
Oh my God, there's an exceptions clause. Did you notice the exceptions clause? Okay, so when you all are first-year students, do not misquote the Constitution. Kind of basic stuff. Do not misquote the Constitution. Okay, does either one of you want to say why he might have not quoted the exceptions clause when he quoted the Constitution? Go ahead.
The exceptions clause would seem to imply that Congress has a little bit more power to limit or even expand original Supreme Court jurisdiction.
Yeah, it kind of suggests that maybe Congress could expand where original jurisdiction is. Now, what might the response to that be? What might the exceptions clause apply to? Someone new? I'm on a relentless quest, people. Great. Okay. I will just tell you, as a professor, I'm on a relentless quest for total participation. I will not demand that today, but I'm going to keep waiting. Go ahead.
Disputes between states.
Say more.
Like, if two states are having issue with one another, it's not clear that it would fall under, like, one state's jurisdiction to have original jurisdiction over it, so then you would need a higher court to decide that.
Okay, so that's totally a possibility. It's not what I had in mind, but I'm so glad you raised your hand. Do it again. Don't be deterred. Okay, so what might the exceptions clause apply to that wouldn't help the case I'm trying to make? Go ahead.
Judicial Act of 1789.
Well, so this is Article 3, right? So this is the Constitution. So it's going to apply to everything. It's going to apply to all statutes, yeah.
The appellate jurisdiction that the Supreme Court has, it's not about the part about the original jurisdiction, it's about the second clause.
Tell me about punctuation and why that might be.
There's a comma.
There's a period. Where's the period?
After after jurisdiction?
Yes. So the first sentence is about original jurisdiction, and the sentence is about appellate jurisdiction. So it is possible that the exceptions clause only means they could give appellate jurisdiction where that sentence doesn't say. But does it have to mean that?
Not necessarily.
Not necessarily. And I'm just going to tell you, they didn't think about punctuation the way we do. Have you read the Second Amendment? There's a crazy comma, there's no causal relationship, right? That's why we're debating it all the time, right? They didn't think about punctuation the way you do. So are we going to put all that weight on a period? It could be the case. It could be the case that the exceptions clause applies to both appellate jurisdiction and original jurisdiction, and that Congress has discretion to expand either or both of those. Or everybody with me? Okay. There's a second problem. There's a second problem with Marshall's argument. Let's remember, Marshall's argument is Article 3 does not give Congress the power to expand original jurisdiction beyond what it says here, and in particular to expand original jurisdiction to include a mandamus. Anybody have a sense of what the additional argument against Marshall might be? This is a hard one, so I'm not going to wait forever. Anybody new have a sense of what this additional argument might be? Marshall treats this distribution of original and appellate jurisdiction as if it's a ceiling. But what if it's a floor? What if it means, at the very least, these cases get original and those cases get appellate? There's nothing in here that says only these cases get original. So what if I said, I'm going to give you some potato chips, and I'm going to give you a chocolate bar? That's rule. That's my rule number one. That's my Constitution. You get potato chips and you get a chocolate bar. Have I violated my rule if I give you a chocolate bar and potato chips? I have not violated my rule, because my rule is a floor, not a ceiling. And Marshall acts like this is a ceiling. He is trying to create a conflict between the Constitution and the statute. I'm not saying that my readings are better than Marshall's readings. All I'm saying is Marshall's readings are not necessary readings. They are not required by the Constitution. He is exercising discretion in his determination that the original jurisdiction is limited to the categories in that first sentence. Is everybody with me? Okay. Do you think Marshall's reading is the best reading? A couple of you. Do you think it's a plausible reading? Do you think the other readings are plausible readings? Yeah! Okay, so he is making choices about his reading, right? He is making choices about his reading. Now, I want to mention one more thing. So he says, in the middle of page 4, he says, if you went with one of my readings, the subsequent part of the section would be mere surplusage. Why would you say it? Well, we just said why you would say it, right? Maybe Congress can make exceptions. Maybe it's a floor, not a ceiling, right? But there's a Latin phrase. Any classics majors? Ah, a couple. Okay, Latin phrase. Expressio unius est exclusio alterius. Any idea what that means? Ha! Any idea?
The expression of one thing excludes the other.
The expression of one thing excludes the other thing. So if they said this is original and that's appellate, that's all you get. By the way, anybody know, does the Constitution say there's judicial review? Does it say there's a veto power? Does it say there's impeachment? It says impeachment. It says veto power. It has the other two checks right there in the Constitution, but it doesn't mention judicial review. Maybe he proves too much with his expressio unius kind of thing, right? He's not going to like that if you start asking that about, well, why wasn't judicial review mentioned? When veto is mentioned and impeachment is mentioned, right? Why wasn't judicial review mentioned? Okay, so what do you do if there's a conflict, which he's decided that there is, between the statute and the Constitution? What do you do?
Resolve it in favor of the Constitution.
Resolve it in favor of the Constitution. You strike down the law. You strike down the law, and this is the advertised part of the case. This is the main reason that Marshall gets the big chair and that his writings are on the walls of the Supreme Court. Marshall says the court has the power of judicial review over legislation. The court has the power to say that statutes duly passed by Congress and signed by the president, or vetoed and passed by 2/3 of Congress, are not valid because the court has determined that they conflict with the Constitution. So he makes two different kinds of arguments about this. There are two parts to his argument about why we have to have judicial review. The first part is about the Constitution being supreme. The Constitution being supreme. What kind of Constitution do we have? What kind of Constitution do we have? Yeah. A written Constitution. We have a written Constitution. Why would you write the Constitution down if it wasn't going to be supreme? That's what he says, right? We have a written Constitution and it must be supreme. Now, I will say, there are many constitutions in the world that are hortatory, that do not lead to judicial review, or that have legislative review. So it is not actually necessarily the case that if you have a written constitution, you must have judicial review. But he says the Constitution is supreme. Does anybody see in there, what arguments does he make about why the Constitution is supreme? Somebody new. If it's not supreme, why have one at all? He's got a couple other, he's got maybe one other argument. Yeah?
That it would be like any other law.
It would be like any other law. It would be like any other law. The whole point of the Constitution is that it's supreme. There's also Article 6, the Supremacy Clause. Now, the Supremacy Clause doesn't only say the Constitution. The Supremacy Clause says the Constitution and the laws of the United States. But he says Constitution comes first. How strong is that? I don't know if that's his best argument, right? But he says the whole point of a written Constitution is that it's enforceable. The whole point is that it's going to constrain us. It's going to constrain the laws that we are going to make. Okay. The second part is, who decides what the Constitution means? And what does Marshall say? The court. The court decides. Remember the big chair. Who decides what the Constitution means?
The court.
Okay, the court. The court. Now he's got a couple of flimsy arguments from the text. Again, the Supremacy Clause. He talks about the oath that judges take. Do you know who else takes oaths? Yeah. Everybody. Everybody takes oaths. That's not special. That's not special to the judges. Okay. But that's not really what he wants to say. Why does he say that the judiciary, the court, should decide what the Constitution means? And this is etched into the walls of the Supreme Court. What does he say? One of the most famous lines in all of constitutional law. Anybody notice it? Anybody new notice it? I'll give you a hint. It's on page 5. Toward the bottom of page 5. Somebody new. Go ahead.
It is emphatically the province and duty of the judicial department to say what the law is.
Yes. It is emphatically the duty and the province and the duty of the judicial department to say what the law is. One of the most famous lines in constitutional law. You will see it used in many other cases when you are in constitutional law, and you should always have your antenna up when it's used, because they are trying to make some arguments that might be a little iffy, and they want the big man right there with them. It is the province of the court. And usually duty is left out. It's not about duty, it's about province. It's about the power of the court to say what the law is. What do judges do? What do lawyers do? Read texts, compare texts, right? Marshall is saying you take the one, I can't even do that, you take the one and you put it down next to the other and you read them and you see if they conflict, because that's what judges do. They read documents and they interpret them. And if they conflict, which one rules? The Constitution. If they conflict, the Constitution rules. Now, the examples that he gives, and you only have one here, is there's a rule, no taxes or duties. What if they put a tax? That's pretty clear, right? Case here, not as clear. Very few of you raised your hands when I asked, is Marshall's reading the best reading? There are multiple possible readings. So the way he describes the process, clear cut. You have to be 25 to run for Congress. What if Congress passes a law? It says you could be 24. Can't do that, right? That would be clear. This is less clear. He is bending over backwards to read the Constitution and interpret it in a way so that he finds this statute unconstitutional. So he's suggesting not only judicial review, but judicial review that takes interpretive work. Judicial review that is not just about a clear-cut violation of something that is in the Constitution. Now, when I say that John Marshall gets the big chair because he created judicial review, I don't mean he created it from whole cloth. Now, he does not make historical arguments in this opinion. They were not left out. He does not make them, which might make you think something about, well, where does original intent come from, original public meaning, when does that start? He doesn't make those arguments. There are other Marshall opinions where he does make historical arguments, but not here. And it might make you think maybe the historical arguments aren't so good for him. That's why he's not making them, right? So the conventional wisdom of historians is there is some evidence that judicial review was contemplated by the framers. There's some evidence that it was contemplated in only clear-cut cases. There's some evidence that it was thought that there would be some kind of popular sovereignty, that the people would speak when there was something that was unconstitutional. But there is evidence that there was judicial review contemplated. Now, it's a little bit weird that's not in the Constitution, especially because there was no judicial review in the British Constitution, and that's the Constitution we're writing against, right? So you'd think if they meant it to be there, they would have put it there. They don't put it there. But, so when I say he created judicial review, he did. That's what's going on in this case. But it's not from whole cloth. It's not like he made it up and no one ever thought it might be there. No one ever contemplated. Hamilton talks about it in Federalist Papers number 78, right? So it's totally a possibility. Okay. So who won this case? Who won this case? Adams and Marshall or Madison and Jefferson? Everybody. Madison, Jefferson. You're confused because who really won this case? Oh, yeah. You guys are right there with me. Marshall really won this case. Okay. But in terms of administrations, right, it was the Jefferson administration that won this case, not the Adams administration. Why was Marshall so intent on striking down this law? Somebody knew. Why was Marshall so intent on striking down this law?
I assume, like, if you think about it in terms of, like, a more political way, it's like he can give them, like, a short-term victory, but long-term, that's his power to actually.
Long-term, he's thinking long-term. And it's not only that he can give them a short-term victory. What might happen? It goes beyond that, you're right. But what might happen if he says this statute is constitutional and we are issuing a mandamus to Madison? What might happen?
The president might not follow it, and the court loses power.
if Marshall issues this mandamus, does anyone remember what happened at the trial? Madison didn't show up for the trial. What is to make anyone think that the Supreme Court issuing a mandamus would be followed? And then the problems of the court and having no power, there it goes, totally gone. Because the court has no army. The judiciary has no army. The judiciary has no money. It does not have the power of the purse. It does not have the power of physical force. The judiciary has only the legitimacy of the decisions that it writes. It has been called by legal scholar Alexander Bickel the least dangerous branch. It must rely on the other branches to enforce what it says. So the brilliance of this opinion and the irony of this opinion is that Marshall strikes down a congressional statute for the first time in American history and establishes the authority of the court to do so without giving anyone any opportunity to test it. There is no way for Jefferson to defy him because there's nothing to do. No mandamus will issue. It's brilliant. It's utterly brilliant. Okay, so let's just recall, here's what happens. Marshall establishes that the judiciary can review executive actions. Only non-political legal executive actions, not political ones, so it establishes the political question doctrine, but it establishes that the Supreme Court can review executive actions, and who decides which executive actions? The court decides which executive actions, and it determines that the Supreme Court has the power of judicial review over congressional statutes. Okay. Even in cases that might not be clear-cut, even in cases that might not be clear-cut, the Supreme Court can override the will of the people as established by congressional statutes. And of course, he does all of this while avoiding the exercise of power and avoiding any opportunity for Jefferson and Madison to defy him and defy the court. This case leads to, and if you were in my class, this is what we would do in the next class session, leads to the big questions of constitutional law, which you've already identified for us. The main big question of constitutional law is judicial review justified and justifiable, and why? And the other way to put the question is to say, why should 9 unelected judges get to invalidate democratically passed laws? And that's what's called the counter-majoritarian difficulty. The difficulty is we say we have a majoritarian system of government, and yet these 9 unelected judges can undo any law we pass. So you all should think about what laws are important to you. Do you want judges to be able to strike them down? Now you might think, I would encourage you to think about laws you like and whether judges should be allowed to strike them down. And think about laws you don't like and should judges be able to strike them down. Because it's not that easy to come to one answer for both the laws you like and the laws you don't like. But that is the challenge of constitutional law, is identifying how you interpret the Constitution so that you can consistently answer those questions. And that involves 3 additional theoretical questions. What is a constitution? Is a constitution just a system of government? Is it the rules of the road? Is it just the structure laid out there? Is it an aspiration of how we treat each other in our political community? Is it an aspiration of values? Does it have values? Is it value neutral? Does it just have processes? What is it? Who interprets it? We now know after Marbury the court interprets it, but only the court? Should the other branches also interpret it? Should Congress ask itself whether something is constitutional when it passes a law? And should it define constitutionality the same way the court does? Or should Congress have its own views of constitutionality? And what about outside of government? Shouldn't all of you be interpreters of the Constitution? We the people? Aren't we all interpreters of the Constitution? As lawyers, aren't you especially interpreters of the Constitution? So who interprets the Constitution? What is it? Who interprets it? And how do we interpret it? Right? That's a question you're going to spend lots of time. Every case is about how we interpret the Constitution and constitutional law. Do we interpret the text? Do we interpret the history? Are we looking at the original public meaning? Are we looking at more recent historical practice? Are we looking at natural law? Are we looking at values? Are we looking at consensus today, a living constitutionalism? There are many ways you could interpret the Constitution. And in every case, whether they say so or not, the judges are using certain methods and not other methods. And so the challenge for you when you come to law school and you read the Constitution as lawyers, which you've now already started to do, is to figure out, what do I think of judicial review? Can I resolve the counter-majoritarian difficulty? What do I think this document is? Who should interpret it, and how should we do so? I will leave further deliberation of those questions to your first law constitutional law teachers. I hope that might be me. I hope that might be here. But wherever it is, I hope you will take seriously the obligation that you take on as a lawyer in this country to read the Constitution and interpret it and make it your own. So thank you all for being here. Have a wonderful rest of your Admitted Students Open House.